I can hear you as well.
I'll sign off my device and maybe that's the problem.
I can hear you. Before you sign off, I just want to confirm, Mr. Reed was not brought over. Is that correct? I mean, that was the plan?
Right. I canceled that transport, yes.
Okay, thank you. Are you all here for Mr. Reed? Yes. So I'll give you an update so you don't wait around all day. As you know, he has 9, count them, 9 unindicted burglaries. And his lawyer and the prosecutor agreed that the state could have a few more weeks to figure out. Now there's a grand jury. To indict a case, we need a grand jury. And the district attorney impaneled 2 grand juries last week. So those grand juries are now starting to work on these cases that have been just sitting around. And so the parties agreed to give the government a few weeks to see if they were going to indict all those burglaries, rather than having Mr. Reed resolve one case and then one more case and then one more case. It makes sense to have them all in one place. So he may have the single most number of unindicted cases. So he's not going anywhere until we figure out what's happening with those. I did get an email from someone with a letter and all that, so I've got that, but we're not in a position to address his situation till the state has a little more time to decide what it's going to do. I did explain to the lawyers that if next time around the state still hasn't figured out what it's going to do, that's not Mr. Reed's problem. And then we might talk about bond, but he has accumulated an unprecedented number of unindicted cases. So for now, he's staying where he is. Okay. You're welcome to stay all day. I just didn't want you wondering when is he going to walk through that door, because there wasn't anything for us to talk about today, given the agreement of the lawyers that the state could have a little more time to try to get organized with all the unindicted cases. All right.
Do you know when there's a court date, another court date?
I don't. It'll be on a published calendar, so however you learn about today, you'll learn about it in the same way when Mr. Reed is on a new calendar.
Okay.
Okay.
Thank you.
You're welcome.
Thank you.
Good morning, Your Honor. This is Attorney Bridges. Did you need me to remain? I just showed up for the Reed case, just in case.
Sir, thank you. You heard were you able to hear what I was saying?
Yes, Your Honor, I did hear what you said.
Fantastic. So when we reconvene next, hopefully the state will have a clearer sense of what's happening or not with those 9 unindicted cases. But until then, you're good to go, Mr. Bridges. Thank you for dialing in.
Okay, you all have a good day.
Judge, your voice is actually kind of loud and echoey. I think some other people hear that as well. The first time you spoke at the very beginning, it was clear, but now it's a bit staticky sounding.
Okay, how about now?
I can hear you, but I can tell that it's a distant microphone.
I think it's the microphone for the witness stand. Whenever the judge speaks, that frame lights up. So maybe if that microphone was turned off, it'll eliminate it.
Can you check the witness stand? So I turned my microphone back on. It seemed to not work well when my microphone was off, but we're checking the witness stand. Now it's muted. Oh, it was not muted. Okay, is that better, Ms. Patel, Mr. Franklin?
No, it's not.
What is it? Too loud, too soft, echoey?
It's echoey.
Warpy, echoey, distorted.
Warpy, right.
Yeah.
Is it better now? Maybe it's warpy because of this mask. Okay, I'll put the mask back on. Well, fortunately, we've got a technician here who will look for the warp.
Yeah, the frame, the litigation manager courtroom 8D frame is still lighting up whenever you speak. So
this one has to be on.
Yep.
This is where the FTR goes to.
Okay, but does the microphone need to be on? How would it have a microphone?
I don't even microphone here.
But maybe the audio is on. Maybe just make sure it's muted.
See, this one can't be muted. This is where the whole.
Let's just try muting it for a second. See what happens.
Yeah, when the gentleman at the witness stand speaks, it's not distorted when he's close to it. That was pretty clear.
You're on mute, Judge.
This is bad? Oh, yeah.
This one down.
Okay.
Okay, try it.
Okay, how about now, Ms. Rivers? How's that?
That's better.
Better. Okay, we may have had the volume up too high on the system that controls everything.
That's much better.
Okay,
Yes, perfect.
great. And I think YouTube is up and running. Thank you very much. So we should be ready to go. We're going to start with position 1, which is Mr. Peck. Do we have a lawyer for Mr. Peck on? I know representation for Mr. Peck has been a source of frustration for us. I'm not seeing Mr. Gregory, and I think he had agreed he was handling all 3 cases. But most importantly, he's on the older rape and the family violence battery. We didn't bring Mr. Peck over. This is just an effort to figure out who is Mr. Peck's lawyer. I'll need help again from the DA's office. Who has this case?
At this moment, I have this case, Judge. And I did reach out to Mr. Gregory, and he indicated to me that he is the attorney for this case. And he indicated he needed discovery from me. So I'm working on getting that to him this week. He's the attorney for all 3 cases? I have him for the older rape case. I think that's the only one I have him listed. So let me get you up to speed. As I'm recalling this, and this was before my time, Mr. Peck was on a trial calendar, and Mr. Gregory, you may have been on the case back then, I don't know, but it was before my time. But for Mr. Gregory to tell you, I don't have discovery for the 18 SC case is remarkable, because it was on a trial calendar. And then he tried to come off the case, not because he didn't have discovery, but for reasons that aren't clear to me. Then he's still on the case. More importantly, we've got the new case now, a 20 SC rape. And the point of today was to figure out if Mr. Gregory, he had said on a Zoom call like this several months ago that he thought he was taking the 20 SC as well. But it sounds like, Ms. Patel, you have not talked to him about the 20 SC? Ms. Snyder's raising her hand.
Yes, Judge. Mr. Gregory sent me an email saying that he would not be taking the 20 SC, so it would be mine. But I also got an email from a Gregory McMillan that he may be taking the case, the 2 rape cases, but I'm not sure because he didn't call me back before court today.
Okay, when did you get the email from Mr. McMillan?
He sent an email to both Ms. Patel and I asking for discovery on the 2 rape cases on March 5th on Friday.
Okay. So he's new to the scene.
He has not filed an entry. I filed all my entries with my new address on it yesterday in an abundance of caution that he doesn't take it. Like you said, I don't want Mr. Peck to be unrepresented.
Right.
But he would be my case if he does not retain Mr. McMillan.
Okay, but only the 20 SC case. Mr. Gregory remains counsel of record on positions 2 and 3.
That is my understanding, yes, sir.
Okay.
And John, speaking about position 2, that's a domestic violence case, so I will be handling position 2 from this point forward.
Got it. I don't expect you're going to need to do much with position 2. Mr. Peck is here? Oh, all right. So much for not transporting Mr. He does not need to come out. All right. So Mr. Peck's here, Ms. Snyder, if you want to come on down and say hi to him. But I don't plan on bringing him out. So I guess Ms. Nelson needs to check with Gregory McMillan. Ms. Snyder, if you could share whatever contact information you have for Mr. McMillan
with Ms. Nelson,
Okay.
then she can reach out, figure out what's going on. And Mr. Gregory, for maybe the 8th time, has not shown up for a calendar call. So Ms. Nelson, if you could just reach out to his office to see if he's planning on gracing us with his presence, that would be wonderful. And we'll figure out what's going on with Mr. McMillan. So Ms. Patel, you will handle 1 and 3, regardless of who's representing Mr. Peck.
That's correct.
Okay, and presumably those are the cases that we will be focused on, given the more serious nature of the allegation. Do either of you know, Ms. Patel or Ms. Beza, is there a similar victim across any of these 3 cases, or are there 3 different victims?
I believe the the 18 SC rape case and the battery family violence have a similar victim. I'm not sure if the 20 SC one is. I can check on
I don't think it is. I'm pretty sure 20 SC is someone different. I just wasn't sure if 17 and 18 SC were the same.
Yeah, 17 and 18 are the same. 20 is new.
Okay. All right then. Well, Mr. Peck did file a pro se demand for speedy trial. So that hit the docket in the 20 SC case. That hit the docket in early February. It's about a month old. And I guess, Ms. Snyder, it's got your name on it, meaning he wrote your name on it. I don't think he got the right address for you, but either way, it's not of any effect because he's got a lawyer one way or the other. I just wanted you to know he is assuming a role in his representation.
Yeah.
I think that's it. That's all we can do with Mr. Peck today. Ms. Nelson will reach out to Mr. McMillan. We'll see if he'll file an entry of appearance, and we may have to have Mr. Gregory once again show cause as to why he didn't show up.
He accepted the email notification of the calendar, so I just sent him another email with the link in case there something went awry.
Okay. Well, we'll be here for him. Let's shift to number 4, Ortega Ramirez. Was he brought over? Okay, also, the calendar said not to be transported. We'll see if he's brought out, and we will follow up with your team to make sure you don't have to needlessly bring people over. So, Siri Patel, is this your case?
Yes, and I have an announcement on this case, Your Honor.
Okay.
The state will be no processing this case, and I'll submit the paperwork this morning.
Well, I think we'll bring Mr. Ortega Ramirez out then for that. We do have an interpreter here. The other Ms. Patel, are you okay if we bring Mr. Ortega Ramirez out and I explain to him what's happening in his case?
Yes, Judge, if you could also explain that he knows this, but he has an ICE hold and that he will be released to that hold instead of to the street.
Got it. All right, it'll be interesting to see what ICE does in this new administration, but I will certainly let him know that. So if we could bring Mr. Ortega Ramirez out, please. Mr. Reed is not here. Good, okay. Okay, were those the only 2 who were up?
No.
We've got other folks who are here.
The cases here are Ortega, O'Neill, and Palmer. Palmer's still downstairs.
Palmer, yeah, I think is this afternoon, and O'Neill was an add-on, but we will certainly, great, we'll handle both those. Thank you. Ms. Rivers, we do not need to take this down.
Ahí está su abogado, ok. Ahí está la fiscal y el juez está aquí. Yo soy el intendente.
Good morning, sir.
Buenos días. Good morning.
I'm Judge McBurney. We've met before.
Soy el juez McBurney y ya tú sabes quién soy yo. Yes.
I have received an announcement from the prosecutor, who is Ms. Patel, not your lawyer, but a different Ms. Patel.
He recibido información de la fiscal, la señora Patel, no su abogado, que tiene el mismo apellido. Es cierta información que debo comunicar.
That the state is dismissing all charges against you.
El gobierno, la fiscalía, está anulando todos los cargos que presentaron contra usted. ¿Cómo?
¿Qué significa eso?
What does that mean?
The case is gone.
Significa que los cargos, el caso que usted tiene aquí, lo cierra.
The state has decided not to prosecute you anymore.
El gobierno ha decidido dejar de enjuiciar contra usted estos cargos.
Okay.
Okay.
Do you understand what I'm saying?
¿Estás entendiendo lo que significa esto?
Yo entiendo que me están quitando los cargos, que ya no van a enjuiciar, nada de eso.
I understand that the charges are being withdrawn, that I'm not going to be prosecuted or anything like that.
Correct, by the district attorney here in Fulton County. That's correct.
Es correcto, esa es la información de la fiscalía del municipio de Fulton que nos han dado en este momento.
Okay.
Okay.
¿Y ahora qué sigue? ¿Qué van a hacer conmigo?
So what happens now? What are they going to do with me?
Good question.
Buena pregunta.
So there is a hold for you, a detainer from ICE, Immigration and Customs Enforcement.
Hay contra usted una orden de detención de inmigración.
So the sheriff's office will call ICE to let them know they need to come pick you up.
La oficina del sheriff, o decir, los oficiales de la cárcel, van a comunicarse con inmigración para pedirles que vengan ellos a retirarlo de nuestra cárcel.
Pero tardan bastante, tardan hasta un mes, 2 meses en venir.
But they take a long time. It could take about a month, 2 months for them to come.
I don't know that. That's a good question. And it may be that your lawyer, the other Ms. Patel on this call, she may have a better sense of how quickly that happens.
En realidad, el juez no sabe que ese es el tiempo que le puede tomar a ellos, pero su abogado, la señora Patel, pudiera indagar directamente con ellos cuánto tiempo va a tomarle a ellos venir a retirarlo.
But I will tell you that generally the sheriff says, we're not going to hold Mr. Ortega Ramirez just for you. You need to come get him.
Pero puedo decirte que los oficiales de la cárcel van a comunicarle a los oficiales de inmigración que ellos deben venir a retirarlo a usted en un tiempo prudente. De lo contrario, van a decirles que no van ellos a tenerlo preso a usted por causa de ellos.
Es que ya me tienen preso 3 años, más de 3 años.
Well, they've been detained over 3 years already now, so.
I understand. Well, it's good news from the government that they're not prosecuting you, but the district attorney's office does not decide what ICE will do.
Son buenas noticias de todas maneras las que usted está recibiendo hoy de manera formal. Pero a la final, la fiscalía de este municipio no es la que decide qué va a hacer inmigración con usted.
Pero entonces la persona que violó a mi hija no va a recibir cargos, no va a ser arrestado, nada.
So then the person that raped my daughter, he's not going to be detained, he's not going to be arrested or anything like that?
So that's not my decision, but it may be that now the government is going to try to get someone different.
Esa no es mi decisión, pero quizás el gobierno ahora puede estar enfocando a otra persona a la que van a detener.
If you think you have information about that, you can share it with your lawyer.
Si usted cree que tiene información que puede asistir al gobierno sobre eso, puede compartirla con su abogado.
No tengo nada.
No, I don't have any.
Okay. Counsel for Mr. Ortega, do you have anything you want to share with him or any insight as to your experience with folks waiting for ICE?
Judge, if you could let him know that Carlos, if you could let him know, I'm going to try to see him tomorrow. get to him and discuss what I think is going to happen next.
Para hablar en persona con usted sobre lo que ella cree va a ocurrir con usted próximamente. Okay.
Ms. Patel, have you had any experience in the last
Experiencia
6 to 12 months with clients who had ICE holds and how long they had to wait before ICE came to get them?
Not in the past year. My understanding has been that it's 72 hours. And that if ICE does not come within a 72-hour period, that they are to be released. But that would, things could change with Sheriff Labat. I'm not sure.
Okay. Mr. Ortega, you should let your lawyer know if you have been waiting for a week and ICE has not shown up.
Debe dejarle saber si dentro de una semana, a partir de hoy, no ha venido inmigración a retirarlo, comuníquese con su abogado.
Because your lawyer then may be able to help make something happen.
Porque de esa manera, entonces, al dejarle saber a su abogado, ella puede moverse para intentar hacer algo diferente.
Including asking me to order the sheriff to release you if ICE won't come pick you up.
Inclusive solicitarme a mí, que yo prepare una orden para pedirle al sheriff de nuestra cárcel que lo deje salir si inmigración no lo retira dentro del tiempo prudencial.
Pero ya son 3 años, ¿no me puede dar una liberación inmediata o algo así?
It's been 3 years. Are you not able to order my immediate release or something like that?
So ICE could not have picked you up until now.
El asunto es que la orden de detención de inmigración entra en vigencia una vez se cierre su caso aquí que acaba de suceder.
While your charges were in place, ICE could not get you. ICE can only get you because now your charges are gone.
Mientras sus cargos se mantenían vigentes contra usted aquí con nosotros, inmigración no podía hacer nada. Como se acaban de cerrar sus cargos, ahora es que inmigración debe actuar, debe movilizarlo.
Entonces, hoy me quitaron los cargos.
So then today my charges were dismissed.
Correct. And so the sheriff calls ICE today and says, come get Ortega Ramirez.
Hoy entonces está autorizado el sheriff de la cárcel a comunicarse con inmigración y a dejarle saber que tú estás listo para que ellos te retiren.
Son 72 horas para que venga inmigración por mí, 3 días.
So that's 72 hours for immigration to come for me, 3 days.
That's what your lawyer thinks is the timeline. She's not promising that. What I'm saying is if it's been a week, she should let me know and I'll get involved.
Eso es lo que su abogado me ha indicado, pero ella en realidad no sabe. Si pasa más de una semana, su abogado debe indicarme a mí. Judge, may the interpreter provide some information? I do immigration interpretation removal hearings. Minimum time is 10 business days for that unit of ICE to come pick up inmates that have been released to their custody.
When you say minimum time, meaning
10 days minimum.
What happens on day 11?
Well, then some attorneys file a writ and then you decide what the jail does.
So your understanding is that ICE is given up to 10 days to act on the notice that they'll get, that their detainer is now valid.
If the detainer is valid. Yes.
Sure. And if they have not acted within 2 weeks, then Ms. Patel, Mr. Ortega's lawyer, could then petition the court to say, we need to do something. It's been 2 weeks, ICE has done nothing, and we'll figure out. That would prompt the state maybe to make an inquiry as well.
Correct, Judge.
Okay.
That's what I have translated in certain.
Ms. Patel, do you mind if Mr. Lyles explains that to your client?
No, Your Honor.
Okay.
Un poquito más, 10 días, técnicamente, que te van a dejar esperando. Si no te vienen a retirar, entonces tu abogado puedes pedirle al juez presentando una orden que el juez ordene a la cárcel y te suelta. Eso ha pasado. pero tienes tú que estar pendiente de los días.
10 días estaba. Es que ahí está horrible. Hay corona donde estoy yo. Se ha ido mucha gente por corona. Imagínense, van 10 personas en menos de 2 semanas.
Yeah, she's saying, well, there is coronavirus where I am being detained at the jail. So 10 days seems to be like some time. And there are people there that have been released because of the risk of getting infected with the virus.
So, Mr. Ortega, I am certain that your lawyer is going to look at what the deadlines are. And as soon as that deadline has been reached, she will let me know if you are still there. We can't move any faster than that.
No podemos movernos más rápido de lo que estamos tratando de hacerlo, pero estoy seguro que su abogado va a informarme después que ella verifique en realidad cuál es el tiempo legal máximo que puede el gobierno federal o las autoridades de inmigración pasar para venir a retirarlo. En lo que ella me informe, entonces daremos el próximo paso.
Miss Patel va a ir a verme mañana, dice.
So, Ms. Patel, are you coming to see me tomorrow? You just said that?
Yes, tomorrow after.
Mañana en la tarde. Okay.
Okay. I wish you luck, and I hope your daughter's doing okay.
Él te desea muy buena suerte y espera pues que estés bien.
Thank you, sir.
You're welcome.
Eso es todo.
Gracias.
Thank you.
All right, Siri Patel, thank you for that announcement. That gets us to positions 5 and 6. Mr. Reed, we've already discussed that. Ms. Hall, you're out there. Good morning, Ms. Hall. What's your sense of what's going to happen there? You're not committing to anything. I know you don't control the charging unit. I'd be surprised if the office decided to ignore 9 unindicted cases. Do you have any sense of a time frame, or are they sort of getting up to speed with these 2 grand juries?
Your Honor, there's no time frame right now. My understanding is that Reed is in line. They have sorted the cases that haven't been indicted as priority. For instance, all jail inmates are priority. So they're the first, of course, the murders are first in line. But Mr. Reed's case has so much discovery that they're trying to get everything from the agencies. It is still in line in its place, but they're getting everything from the agencies for these burglaries, and then it'll be indicted. What she did tell me was it was going to be at least a couple months because the cases that are ready are the ones that are already being pushed to grand jury that was already present at the time.
Well, I got it. So I guess when it's next on the calendar, you'll need to come with your best estimate of what's going to happen, and we'll figure out what we do then.
Okay, I will.
All right, thank you.
You're welcome.
Next up then is Ms. Boyce, and I saw Ms. Boyce on the screen. Who's handling Ms. Boyce's case?
That'll be my case, Your Honor.
All right.
That'll be my case as well, Your Honor.
Okay, so this was on a final plea calendar about a month and a half ago. I'm not remembering why it rolled over. Sharma Patel, why don't you tell me, please, where you think we are?
Yes, Judge. So at the last court date, I had been negotiating with Miss ADA Marshall Hodge about a resolution that involved my client taking classes through DFACS. And the issue then was that no one could get a hold of DFACS. My client has had contact with DFACS, has had an assessment, is starting classes. I've spoken to ADA Siri Patel. We are very, very close to a resolution, something similar to a virtual PTI. The only issue now is that I cannot get proof other than just verbal confirmation of what classes Ms. Boyce is in, because the program will not just release that information without an ROI. I emailed the assessor yesterday to get release of information from them because they have their own form. She was supposed to get it to me yesterday. I'm going to follow up today. Once I have that, I can get the proof to provide to ADA Patel about what their plan in terms of classes was going to be.
Okay.
Yeah, that's correct, Your Honor. And I also spoke to the, I guess, the case manager, and I'm fine moving forward with the DFACS classes. We just wanted to be very specific in the PTI order.
Okay. So what are you all, I appreciate you working on this. So two things. One, if I can help Public Defender Patel in getting information out of DFACS, let me know. You could draft an order. I'll sign it saying, look, you need to disclose this stuff. It sounds like you're going to get it. They're just making you jump through, understandably, some hoops. But if that doesn't work out, let me know, and I'll help in whatever way would get the documentation that ADA Patel understandably wants to see. So that's number one. Number two, so it does sound like this case will resolve. What's the right way for us to keep track of it? I don't mean to drag Ms. Boyce and the two lawyers back on a call too soon, but I don't want too much time to go by given the nature of the charges. What are you proposing, Public Defender Patel?
Your Honor, if we could put it on a status calendar for perhaps late April, I am confident that I think we can have it wrapped up far ahead of time. But in the event that we face difficulty with them providing the information, and I do have to get Your Honor to sign an order, I think that should provide us enough time to get the documents we need to ADA Patel.
And so I'm clear, because I'll make a note, and then Ms. Nelson will probably get that notation on the calendar for late April. What you're trying to get so far unsuccessfully is documentation from DFACS of the nature of the classes Ms. Boyce is taking, and then how far she's gotten. Is that basically it?
Yes, Your Honor.
Okay, and then what you're envisioning is a virtual PTI or a PTI where the primary condition is complete these classes. She's enrolled, and then ADA Patel will agree to move this case to the dead docket for some number of months. That should be a sufficient time for Ms. Boyce to complete the classes in which she's currently enrolled.
Yes, Your Honor.
Okay, I think that makes sense. Ms. Boyce, do you have any questions about what we've been talking about?
Yes, I have one question. They recommended for me and my son to do one of the classes together. I was saying, how could we go about that?
So that's a great question, and it sounds like that's an important class.
Yes.
I suspect that there is a bond condition, maybe that you're not supposed to be around your son.
Yes.
So, Public Defender Patel, perhaps in your request to DFACS, you could see if they would confirm in writing that they believe that it is appropriate for there to be a class that Ms. Boyce and her son attend together. And that would be basis, I believe, for ADA Patel to ask that that bond condition be modified for the purposes of that class. And I'd be inclined to modify it. But of course, DFACS would need to step up and say, we are either requiring this or recommending it. And if they do that in writing, I think we'd be okay.
Family Ties requested for us to do it. So I don't know. I'm waiting on a form or something they supposed to send.
What's Family Ties?
That's the where I get the class, where I'm doing the classes at.
Okay. Okay. So I think PD Patel, you're right that putting this to late April makes sense. It just may take a little bit to pull this information out of DFACS. In the meantime, Ms. Boyce, keep going to those classes and do what you're doing. DA Patel, anything else in Ms. Boyce's case?
No, Your Honor.
PD Patel?
No, Your Honor.
All right. Ms. Boyce, thank you for dialing in.
Thank you so much.
PD Patel, you know how to reach Ms. Boyce. Do we need you to get contact info from her today, or you're good?
I'm okay, Your Honor. I have her number and email address.
Okay, excellent. Thank you.
Thank you.
Sir, yep, let me sign that. Thank you for your help. Sorry he wasn't as happy as he should be with that news. Yeah, well, he's been in for a minute.
And he's got a good chance in immigration anyway, if he wants to try and stay.
Yeah, it was dismissed. I think that would be good. You'll do the math?
Yeah.
I'll just sign it. Okay, great. All right, thank you, sir, for coming by. All right, I have Ms. Hannah next.
Hello, Your Honor.
How are you?
I'm okay. How are you?
Good. Are you doing well isolating?
Yes, I am. I got my first dose yesterday. So
Well, congratulations. Did you have to go to Alabama with Ms. Markowitz?
I did have to go to Alabama. I went to Lancet, Alabama. It is literally the first exit over the border. So
Yep. My wife told me about that. She said that judges, any judge, you could be a judge from Alaska. I assume you could be a judge from Mars, and
Yes.
You can get your shots in Alabama.
And they allow they allow public defenders, but they allow all criminal defense attorneys.
Look at that. Go
have bar
Alabama.
cards. Yeah.
I would not have guessed that, but that's a good development.
Yes. So
If only we were in like Douglas County, it would be easier to get there. But
yes,
it's a
yes.
bit of a hook.
But it was only an hour and 45 minutes, and I live in Chamblee, so
Okay. Well,
not
good.
too bad.
So Ms. Hannah, is she, I've seen Mr. Hodge the whole time. He's been there. But
Yes, Ms.
Mr.
Hannah
Hodge
is. Yeah. Ms. Hannah is not here. We have tried every phone number that we had for her, and that none of them work. We are hoping probation today.
Hold on one second.
Go ahead.
Mr. Abate has an announcement about Ms. Hannah.
I found out this morning that my understanding is Hannah passed away on December 28th, 2020 from a heart attack. I'm attempting to get some sort of confirmation of the death certificate or something of that nature to provide the report and then proceed accordingly.
Okay. Were you able to hear that?
I was not at all.
Okay. You just sit on the other side. I'll repeat it. Mr. Abate believes that Ms. Hannah has passed away, that on December 28th of last year, she had a heart attack. Mr. Abate is going to try to get further documentation of that, but his information is that that's why you're not able to reach Ms. Hannah. I'm sorry to break the news to you in this setting, but that would explain why you've had trouble reaching her.
Yes. Yes, Mr. Abadi, if you can get that information to us, we'll try to get in touch. We couldn't even get in touch with her sister, so I had no knowledge of that. But yeah.
And Mr. Abate just learned that? He wasn't sitting on that information?
No, I'm not.
Yeah.
I'm not suggesting such.
And so we'll need to try to confirm that. If we do, then we're going to focus less on Ms. Hannah's part of the case. Ms. Snyder, is it all right if I ask your client if he knows anything about Ms. Hannah's whereabouts? He may be able to confirm this.
That's fine.
Mr. Hodge, can you hear us?
Yes, I can.
Hey, good morning. I'm Judge McBurney. How are you doing?
Good morning, Judge McBurney.
Hey, Mr. Good. I'm glad you're hanging in there. When's the last time you had any contact with Ms. Hannah?
Yeah, she's gone in December.
Okay. I'm sorry about that. We didn't know. This is not necessarily the best setting to be learning that information. Okay.
Yeah.
I appreciate you sharing that.
Okay, I'm gonna jump off then. If you need me for anything, everyone knows where to reach me.
Yes, she is.
Okay.
You see that?
What is that? I'm sorry, Mr. Hodge.
Is that the funeral? Yeah.
Yeah, that's her.
Okay. Mr. Hodge, it may be that we get you to email that or make a copy for Ms. Snyder, and then she can share it with us. I'm very sorry for your loss and Ms. Hannah's family's loss. Yes, Shubha, you're free to go. Thank you for dialing in. Make sure you get your second shot, okay?
I will, March 31st.
All right.
Okay, bye.
All right. Well, why don't we turn then to positions 9 and 10? Those are Mr. Hodge's cases. Ms. Snyder represents Mr. Hodge. And this is one of the first things I worked on when I took over Judge Reeder's caseload. And there were all sorts of pending motions in the Hodge-Hannah matter, the 13 SC, that had been returned to us by Justice Boggs. And I had ruled on one motion that had been filed by Ms. Hannah's attorney and asked for input on what to do with the second motion. Ms. Snyder had joined or adopted the pleadings that had been filed by Ms. Hannah's attorney. I'm remembering a little bit about the case. I don't know, I guess, Mr. Abate, I'm going to start with you in light of what sounds like confirmed passing of Ms. Hannah, whether the state is going to persist in the 13 SC case just against Mr. Hodge. I appreciate he's got an entirely separate case that we need to talk a little bit about today, just in terms of status. But what is the district attorney's office's position on the 13 SC case now that we're down to just Mr. Hodge?
So I will speak with Ms. Snyder to see if we can, obviously a resolution short of trial is what both parties would prefer due to the age of the case. And I'll take some time to speak to Ms. Snyder this morning and tomorrow about the new things that have come to light today through, I guess, one less defendant on the indictment.
Okay. Ms. Beza, do you have position 10, the family violence ag assault?
I do have position 10, and Ms. Hannah was actually listed as the victim in that case,
Okay.
which I found out.
Yeah, so it sounds like what we ought to do is give Ms. Beza and Mr. Abate an opportunity to think through what makes the most sense, and then confer with Ms. Snyder. I'd like to make it a relatively short fuse, maybe by end of March or early April. We put it back on a status calendar, just status, to figure out what we need to do. If I need to work through the motions that were effectively Hannah motions, but Hodge has adopted them, I will. But it may be, I'm just, my recollection about the older, more serious case is that with Ms. Hannah not in the picture anymore, it may be more resolvable. I don't know anything about the 17 SC case. And the fact that the victim is deceased doesn't necessarily mean that case goes away. It certainly becomes a little more complicated for the state. So, Ms. Snyder, are you okay? Mr. Hodge is on bond, so while these cases are hanging over his head, he is nonetheless free to go about his business. If I give the DA's office a few weeks to huddle up about what they want to do to move forward?
That's fine.
Okay. Mr. Hodge,
Yes,
what we're gonna do is give the prosecutors chance to work through this sad news about Ms. Hannah passing and what that means for your cases. They will then talk to your lawyer, Ms. Snyder, who will be in touch with you, and we'll see maybe at the end of this month or early next month where we are with these two cases. It is definitely time to resolve them, whatever resolving means, if it's a trial or a plea or something else. So I'm going to make sure we keep moving them along, but I do want to give the prosecutors a little bit of time to think through what this change means for their cases. Do you have any questions, Mr. Hodge?
No, sir.
Okay.
I don't have any right now.
Mr. Hodge, are you in the Atlanta area, or where is home for you?
Yes, I live in Atlanta. I live on a Westlake area, close to Hightower.
Got it. So, and how did you get notice of today's calendar? Did you get something in the mail, or did Ms. Snyder call you? How'd you know to get on the line?
I previously got the information from my pretrial officer.
Okay.
And
So it sounds
Ms. Snyder called me yesterday to confirm.
It sounds like you are staying in touch with pretrial.
Yes, Judge McBurney. I'm doing whatever they asked me to do. I've been doing it for a very long time.
Yes, you have. Your name is on a list of folks who've been on pretrial for too long, which is why we need to keep moving the case along. I just want to make sure the system is right. Are you on Ezra Church Drive?
Yes, sir.
Okay, great. Ms. Snyder, anything else for Mr. Hodge today?
No, sir. I have good contact information for him and we've stayed in touch.
Okay. Mr. Abate, anything else?
No, Your Honor.
Does end of this month, early next month give you enough time? I know you've got a few other things you're working on, but this has got to be one of your older cases.
Yes, sir. More than enough time.
Okay. Does that work for you, Ms. Beza?
Yes, Your Honor.
Okay. Mr. Hodge, you're free to go. You'll get notice from pretrial and Ms. Snyder, and maybe even something in the mail when you need to dial back in, okay?
All right.
All right. Stay safe.
Okay, thanks. You too.
How did you get the information that you had?
We spoke to who has her other two biological children this morning. She said she thought she had heard.
Yeah.
And then I Googled it and went on Facebook and all of that.
Yeah. Okay.
Judge, may Mr. Hodge be, oh, there he went. Okay, I just want to make
Well,
sure.
I put him in a waiting room. Do you want me to bring him back?
I can tell him he can go. That would be great. Thank you.
Sure. I thought I had, but I'm bringing him back. Hey, Mr. Hodge, you are free to sign off now, okay?
Okay.
Thanks. I think things are well. Is there a way to slightly turn down the volume of the speakers in here? I control it. It's just what's coming out of here is kind of loud. It's not critical. Okay, that's fine. And we'll see you whatever time across the street. Good. Okay, thanks. Brandon Murphy was null prost. Thank you for that, Ms. Hall. The order made clear why that was happening. And I think that's it other than O'Neill for this morning.
Your Honor, Ed Adams, I'm present for O'Neill.
Great. Are we going to get Ms. Convery or do we have Mr. Abate for that?
I'm going to cover for Ms. Convery.
Okay. And is Mr. O'Neill up? Okay. We're going to bring Mr. O'Neill out into court. Okay, Mr. Adams?
That'd be great.
Great. And my understanding is it's a plea. Is that what's scheduled?
Yes, Your Honor.
Okay. To both cases?
Yes, Your Honor.
All right. I got that second in back. Yes, I do.
Your Honor.
Yes, sir. Yes, ma'am. Ms. Hall, was that you?
Yes, Your Honor. I was going to say that concludes my business. May I be excused?
You may. Let me just make sure we've got this afternoon a motion that's with Mr. Franklin, and I think your appellate section is handling that. But then I have something down, a plea. Is that your case? Are you coming back or is that someone else's?
It's my case, Mr. Palmer. Me and Patel.
Great. So you'll be back at 3-ish for that?
Yes, Your Honor.
Great. Okay. See you then.
See you later.
May I be excused as well, Your Honor? That's it for me.
Yes, ma'am. Thank you.
Thank you.
Me as well, Your Honor.
Ms.
as well,
Snyder,
Your
hold
Honor.
on. Don't go, Ms. Snyder. Ms. Patel, you can go. I'm supposed to ask you about a C3 attorney, but what is that? Ms. Nelson, what case are we asking Ms. Snyder about?
Sorry, Judge, I put a note on the calendar. Hold on just a sec.
The guy in DOC, Miss Nelson?
What's his name? Goodness.
Pritchard?
Yes.
I sent the form, but I don't think I got a response. I'll follow up on that today.
Okay, thank you.
No problem.
All right. Then you can go, but go follow up on it.
Thank you.
All right. Mr. O'Neill, how are you?
I'm doing good, John.
Good. Can you see your attorney, Mr. Adams, right there? You can sort of see, there's his face. You see him?
Yes, sir.
Great. My understanding, Mr. O'Neill, is that we're gonna take pleas in your two cases. Is that what you thought was gonna happen?
Yes, sir.
All right, we're gonna get on the record then. It is 19 SC 165326 and 21 SC 177354. Mr. O'Neill is here in court. His attorney, Mr. Adams, is appearing remotely. Mr. O'Neill, you have the right to have your attorney in court if it's safe for him to be here. But you can waive that right and have him present, which he is, but have him appearing remotely. Are you okay with the fact that Mr. Adams is going to be appearing on the screen rather than here in court?
Yes, Sean.
Okay. If you have any questions of him or me while we're going through this, just let me know. I can't really set it up so you and he can speak privately, but if it's not a sensitive question, you can ask him and he'll give you the answer. All right?
Okay.
Okay. In just a moment, Mr. Abate, who is handling your cases for the district attorney's office, is going to put you under oath. Once you're under oath, it's important that you answer his questions and mine, and we're both going to have questions for you, truthfully and completely. If at any time you can't hear Mr. Adams or you're not following what anyone is saying because it doesn't make sense, let me know and we'll make sure you do, okay?
Yes, sir.
Great. Mr. Abate?
Judge, you want me to sit here or go up there?
Wherever you'd like to be. Ms. Rivers can hear you as long as you're near a microphone. So you be at a position of comfort.
All right, Mr. O'Neill, if you'll raise your right hand. You solemnly swear or affirm that the testimony about the given and matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes, sir.
Mr. Abadi, you have to speak up a little bit for me.
Okay. Could you please state your true, correct, and legal name for the record?
Marquise O'Neill.
And do you understand that you are indicted in case number 19 SC 165326?
Yes, sir.
And you're also, there was an accusation that you waived your right to an indictment in accusation number 21 SC 177354?
Yes, sir.
Okay. And so are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you take on a daily basis that you didn't take today?
No, sir.
All right. How old are you, sir, and how far did you go in school?
I'm 26. I made it to the 12th.
12? Okay.
Did you graduate or not quite?
No, I didn't graduate.
No GED?
No, sir.
Not yet.
Not yet.
Okay.
And Mr. O'Neill, are you able to read, write, and understand the English language?
Yes, sir.
And do you understand, sir, in indictment number 19 SC 165326, you are charged in 2 counts of the 7-count indictment. Count 2, participation in criminal street gang activity, and count 5, possession of marijuana with the intent to distribute?
Yes, sir.
Okay. And do you understand that you have the right to plead either guilty or not guilty to these charges? And if you pled not guilty or remain silent, you may receive a jury trial.
Yes, sir.
And have you had an opportunity to speak with your attorney, Mr. Adams, prior to this about the rights that you're waiving by taking a plea here today?
Yes, I have, but I just wanted to clear them all the way up. But yes, I have.
You wanted to clear your way up?
Yes, because I talked to him about it. I have talked to him about it.
Do you need any more time to speak to him about what's going on today?
No, unless he needed to let me know anything, then no.
Okay.
Mr. Adams, do you have any updates for Mr. O'Neill or are things just as you left them with him? You're on mute.
You're on mute.
Yeah, just as I left them, y'all.
Okay. So Mr. O'Neill, Mr. Abate is going to cover all those rights. If when he's done, you have questions for me or for Mr. Adams, just let me know.
Okay.
And in speaking with Mr. Adams and working with him on your cases, are you satisfied with the services he's provided you?
Yes, sir.
Okay. And Mr. Adams, do you waive formal reading of the indictment,
We do.
as well as do you waive any and all defects in the indictment, including any with respect to your client's name?
We do.
Okay. And Mr. O'Neill, has your attorney advised you of the minimum and maximum sentences for each charge you're pleading to in both case numbers?
Yes.
Okay. And did he advise you that in indictment number 19 SC 165326, that the minimum for participation in criminal street gang activity is 5 years, with the maximum being 20 years?
Yes and no. Yes, I have though. Yes,
Let
I
me
have.
explain it further. The 5 years that you're hearing as the minimum
Mhm.
can be served on probation, can be served in custody, or can be suspended.
Mhm.
Okay. And then in count 5 of that indictment, possession of marijuana with the intent to distribute, the minimum being 1 year, the maximum being 10 years.
Yes, sir.
Okay. And then the accusation, our case number 21 SC 177354, which is an 8-count indictment. The first count being possession of a controlled substance in Schedule 2 with the intent to distribute, which is the minimum is 5 years, the maximum being 30 years, sir.
Mhm.
Say
You need
yes.
to say yes or no.
Sir? Yes, sir.
Great.
Count 2, possession of a controlled substance in Schedule, what was found on your person was Schedule 5, the minimum being 1 year, the maximum being 3 years.
Yes, sir.
And then the possession of marijuana with the intent to distribute, again, minimum is 1 year, the maximum being 10 years.
Yes, sir.
And then count 4, the possession of a firearm during the commission of a felony, which is 5 years, that has to be served, or it has to be consecutive to any sentence you receive.
Yes,
but
sir.
it can be suspended, probated,
Sir.
or served in custody.
Yes, sir.
Okay. And then count 5, abandonment of controlled substance. Count 6, obstruction of a law enforcement officer. Count 7, fleeing or attempting to elude a police officer. And count 8, expired or no license plate or decal, all being misdemeanors, with the minimum being 1 day, the maximum being 12 months.
Yes, sir.
Okay. Do you have any questions about the minimum or maximum for each of the charges we just went over?
No, sir.
Okay.
Can you please repeat count 2's sentencing range? I was looking at Mr. O'Neill's old case and what a co-defendant got.
Yes, Judge, it's 1 to 3 years.
1 to 3. Thank you.
No problem. And do you understand that this is a negotiated plea of guilty, which means the state will make a joint recommendation with your counsel of a sentence of 10 years to serve 1 year with the balance to be probated as a global sentence for both of your cases?
Yes, sir. What's that? That mean like probation?
10 years, yeah, so it's a 10-year sentence with a service of 1 year in custody, and you'll get credit for whatever time you've served in the Fulton County Jail currently. And then the remaining time of those 10 years, so 9 years or less, will be on probation.
Yes, sir.
Okay. But do you understand that the court does not have to accept that sentence and can send it to you as he sees fit?
Yes, sir.
Okay. And do you understand that this plea may be used to enhance sentencing and other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, sir.
And do you understand that you waive any and all defenses by entering a plea of guilty here today, sir?
Yes, sir.
And do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and to not incriminate yourself?
Yes, sir.
You also understand that by pleading guilty, you're giving up or waiving the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or court-appointed counsel if you were unable to afford an attorney at the trial of your case,
Yes, sir.
the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, the right to an appeal should you be convicted of these charges. Do you understand that by taking a plea of guilty here today, you are waiving all of those rights for both of your cases?
Yes, sir.
All right. And Mr. O'Neill, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No, sir.
And do you understand that if you are not a United States citizen, a guilty plea will affect your immigration status and subject you to deportation regardless of any advice given to you by your attorney or anyone else?
Yes, sir.
And is it your decision to waive these rights and enter a guilty plea here today because you're in fact guilty, sir?
You say it again?
Is it your decision to waive these rights and
Yes.
enter a guilty plea because you're in fact guilty?
Yes, sir.
Okay. And how do you plead to the charges in indictment number 19 SC 165326, count 2, participation in criminal street gang activity?
Guilty.
And how do you plead to count 5, possession of marijuana with the intent to distribute in that same indictment?
Guilty.
And how do you plead in indictment number, or excuse me, accusation number 21 SC 177354, count 1, possession of a controlled substance in Schedule 2 with the intent to distribute?
Guilty.
And count 2, possession of a controlled substance in Schedule 5?
Guilty.
And count 3, possession of marijuana with the intent to distribute?
Guilty.
And count 4 is the possession of a firearm during the commission of a felony?
Guilty.
And then count 5 is the abandonment of a controlled substance, a misdemeanor?
Guilty.
Count 6 is the obstruction of a law enforcement officer, also a misdemeanor?
Guilty.
And then count 7 and 8 are both misdemeanors, and fleeing or attempting to elude a police officer is count 7?
Guilty.
And how do you plead to count 8, expired or no license plate or decal?
Guilty.
Okay. And sir, is this guilty plea freely and voluntarily given with full knowledge of all the charges against you?
Yes, sir.
Okay. Understand that you may only have a limited right to appeal this guilty plea conviction.
Yes, sir.
Do you also understand that you only have 4 years from today for the felony charges and 12 months from today for the misdemeanor charges to file what's called a habeas corpus petition with respect to this guilty plea?
Yes, sir.
And Mr. Adams explained to you what that was?
Yes, from like, with all of it together?
Say that one more time.
What you mean, like with all of it together? All my.
Did he explain to you specifically what the appellate situation is? That there's not a whole lot you can appeal if you plead guilty. You can appeal the sentence in a limited way. And then you have these things called habeas rights, where you're, after you've been convicted, challenging what happened. But there's a time limit on doing that. And that's all Mr. Abate's wanting to make sure you understand, that
Yes, sir.
10 years from now would be too late to do it.
Okay. Yes, sir.
Your Honor, as it pertains to the defendant's criminal history, from my review of the file, he has no felony convictions. He had 2 prior cases, both involving the possession of marijuana with the intent to distribute in 2016 and 17. But both cases were PTI'd in front of Judge Woodson, a former non-complex judge here in Fulton County. Your Honor, had this case proceeded to trial, or both of these cases proceeded to trial, as it pertains to 19 SC 165326, the case, the state would have proved beyond a reasonable doubt that on May 23rd of 2017, the FIT team received a dispatch call to 576 Lee Street, Atlanta, Georgia, here in Fulton County. When officers respond, the defendant, Mr. O'Neill, and his co-defendants were all in the area and began to flee. As officers approached the call for help, one of the FIT members who was present recognized the defendant as well as his co-defendants as active FBN gang members, which, excuse my language, is fuck about nothing gang. Upon their apprehension, the defendant was searched, and they did find that he possessed 8 small baggies of marijuana for sale. And through the gang expert, the state would have been able to prove that the selling of or distributing with the intent, possessing marijuana with the intent to distribute is commonly used as a common way for gangs continue to make money in order to keep the gang going and being able to do the things that they do in order to keep their status in the community. Had that case proceeded to trial, that would have been the evidence that the state would have been able to prove beyond a reasonable doubt. As to the second case, 21 SC 177354, the facts of this case, Your Honor, is on September 18th of 2020 in the area of the West End area here in Atlanta at 115 Leather Circle, Atlanta, Georgia, around 5 p.m. A traffic officer was patrolling the area and got behind the defendant's vehicle. He did not have a license plate or decal on his where his license plate should be. The officer put his blue lights on and attempted to stop the defendant. He began to stop, and as the officer slowed down and also began to stop, the defendant then gassed it and took off. The officer did follow him for a short period of time, where the defendant did stop in front of 115 Leather Circle. As soon as he stopped his vehicle, he fled from his vehicle and ran into a wooded area next to that house and threw a bag of items, full of items, into the woods. But the defendant was quickly apprehended by the officer. Upon his arrest and the search of the wooded area, the officers did locate the bag, which was full of over 50 grams of marijuana divided into several small bags, a bottle of promethazine, a scale, and over 20 pills of oxycodone, all relating to the charges in which the defendant has pled guilty to today, Your Honor. Had the state proceeded to trial, that's what the state would have been able to prove beyond a reasonable doubt for both of the cases. As stated earlier, Ms. Convery and Mr. Adams had discussed at length a negotiated resolution, and after their discussions, they were able to come to the resolution of 10 years to serve 1 year with the balance to be served on probation, Your Honor. The only special condition that Ms. Convery had communicated with me was that the defendant shall not associate with any gang members at all, specifically his affiliated gang, the FBN gang, but also is to remain away from all gang members for his own safety and the community's safety, as well as we were unsure as to how far the defendant had gone into school. One of the conditions would be that he either enroll back into high school and go to college, or at least get his GED and start some trade school or maintain employment, Your Honor.
Okay.
Nothing further from the state.
That was a lot. Thank you. Let me start with probation. Ms. Crawford, Mr. Abate said no adult felony criminal history for Mr. O'Neill here in Georgia. Do you agree?
Yes, sir, that's correct. No history found with Georgia.
Okay, thank you. Mr. Adams, what do you want to share with me about Mr. O'Neill?
I want to share with you, he's 26, as stated. He has no children. He is employed, but he's also self-employed. He has a t-shirt shop. And he will be living with his mother in East Point, Georgia. And the recommendation, just so there's no confusion, that's 1 year community time served is what I'm not sure how long he's been in, but we'd ask you to accept the recommendation, you know.
So there is some confusion about that. I don't know if Mr. Abate needs to check with Ms. Convery, or he's pretty clear about what Ms. Convery said. But Mr. Abate has said now, in response to your client asking, me asking, and just on his own, that what was negotiated was 10 to serve 1, balance probated, so that I don't know how long Mr. O'Neill's been in, and I actually just learned how long he's been in. But he'll be doing a little more time based on what I'm hearing Mr. Abate say. Mr. Adams, you're saying it was reduced to time served. That's a different sentence. So let me pivot back to Mr. Abate to see if he has other information.
I don't have other information, but I have an issue commuting.
Okay. So what you're representing, Mr. Adams, is that you and Ms. Convery had talked about reduced to time served, not actually served the full year?
That's correct, John. I'm not sure how long he's been in. I think it's quite a while. I'm not sure exactly how long, but it was long enough to do community time served.
Should be about 6 months. I've got down that you went in on September 18th, the day of the car chase, and you got arrested in the woods, and you have not been out since.
No, sir.
So about 6 months.
Yes, sir.
Longest you've been in?
Yes, sir.
How's it been?
Hard.
Like to get out?
Yes, sir.
Okay.
I may not be a supervisor anymore, but I think I can.
I'm fine. I just didn't, if that's what Ms. Convery, if she had negotiated and thought it was to serve, then that's, so,
It's a few months. I'm okay with that.
okay,
She won't have a problem with it.
fine. I wasn't questioning your authority. I just wanted to make sure that because she wasn't here, there wasn't something being done. Okay. Mr. Adams, anything else? I'm sorry, we got a little sidetracked on that. Anything else you wanted to share?
I just want to know if Mr. O'Neill has any concerns or questions.
Do you have any questions for, I have a few questions for you, but do you have any questions for Mr. Adams before I ask you?
No, I just wanted to know about just the time served. That's all I wanted to know.
Okay, well, you'll hear about that from me. Because in the end, that's my decision. But Mr. Adams is saying that what he thinks was negotiated was a recommendation of 10 serve 1 with that 1 reduced to time served. Mr. Abate has said he does not oppose that. So it's now with me. Where did you go to high school?
Darrell High School. I went to Tri-Cities High School and Darrell High School.
Where did you do your junior and senior years?
Darrell High School in Atlanta, Georgia.
So you started at Tri-Cities?
Mhm.
And then what, did you and your mom move and you were at Darrell?
Yes, sir.
And how far did you get through your senior year?
To like half of the year.
And what happened?
It just wasn't, I just had, I don't know, just a lot going on.
Okay.
With the movie situation and a lot.
Okay. Mr. Adams says you have no kids. Is that correct?
I had one on the way.
One on the way.
Yes,
Okay.
sir.
When is this kid due?
Due in May.
Okay. Do you know boy or girl?
A little boy.
And where does his mom live? In the Atlanta area?
Yes, sir.
Okay. Have you been keeping up with her while you've been in?
Yes, sir.
Okay. Tell me about this t-shirt shop.
The t-shirt shop is something that I started from a person who I used to go to school with. And I knew his dad. So I always used to go downtown. He taught me how to do it. Then I started doing it in the West End at A&O Printing. And I've just been doing it by myself ever since. I've just been doing it by myself.
So is there a place that you had been renting that now is shut down because you've been out, or you sort of do it out of your own house?
Yes, it's been shut down. I was doing it in the West End. We had like a boutique.
Mhm.
But since I've been in here, it's just been like, it's been up.
How long had you been doing that before you got locked up?
Like a year.
Okay. You're going to try to get back into that or something different?
Yes, sir. I want to do a lot, but yes, that's one. That's one.
What else?
I want to get into like just owning my own business. Just owning my own business, trying to do a lot of things, shoes. I'm into fashion, so I just want to do a lot of different stuff.
Okay. Well, those are all promising. It sounds like you also have a little side hustle that gets you into some trouble, and you're going to need to figure out which way you're going to go. You got a little guy coming around, and he's not going to want to see you dressed like that. You won't be much of a presence in his life if you don't move past that. And I appreciate there's quick money and there's hard money.
Yes, sir.
You got to work harder making t-shirts and selling them than a quick deal with some pills, but they're just very different consequences on that side. And now you've learned that. I just hope it sticks with you. I know there is a certain glamour to it, and you may just know guys like, hey, this will be easy. Just deliver this, take this backpack. You saw what happens, and they're not bailing you out, and you're doing the time, and you're away from your family. I'm sure your mom is stressed out. You're in jail during the pandemic.
Yes, Your Honor.
But it's your fault. It's not anyone else's. I'm glad to hear these other options that you've got and that you've done before. I just hope they can take up more of your time rather than less.
Trust me, I'm done.
All right. Well, we'll find out. I hope you are. I want to trust you. Some folks struggle getting away from it. It's not easy to walk away from it. You're hanging out with certain guys and they haven't turned the corner that you feel like you've turned, and they pull you back in. So you just need to be real thoughtful about who you associate with when you get out. It sounds like you got some folks who care about you, who are moving in a good direction. you got some folks who may also care about you, but they move in a different direction.
Yes, sir.
And those blue lights come on and you run and they catch you and it gets messy. All right, let me see if I had any other questions. So when you get out, you're gonna live with your mom
Yes, Your Honor.
in East Point?
Yes, Your Honor.
Okay, and she knows you may get out soon and she's willing to let you stay with her?
Yes, Your Honor.
Where were you living back in September of last year?
September of last year.
When you got arrested, were you living with your mom or staying with
yes,
other
yes,
people?
Yes. No, I was staying with my baby mother, but I just started going back to my mom's house because her husband was on dialysis and stuff. So I just be going back and forth, just helping out.
So who lives in your mom's house? Your stepdad?
Yes,
Your mom? Anyone else?
No, that's it.
So you'll be the third person in the house.
Yes, sir.
Will you have your own room, or are you going to be sleeping on a couch?
No, my own room. My
Okay.
own room, Your Honor.
And are they in a house or an apartment?
It's an apartment in the Lower Village.
Okay. And is your mom working?
Yes, she works.
What does she do?
She work at what is it called? What I do
They cleaning the cars? They selling the
they
cars?
clean detail cars and stuff like that.
Okay. Is she a detailer or is she a cashier or she owns the company?
I'm trying to think of the exact name of it.
Oh, the name
Auction. She works.
Oh, like Mannheim Auction?
Yeah, like the auction.
Okay. And so she helps get the cars ready for sale?
Yes, sir.
Okay. And it sounds like your stepdad maybe is not working if he's on dialysis.
He worked. He used to work. He was in the army. He was in the army.
All right. And you got a little boy coming, so life is going to get complicated. Diapers are not cheap.
I know.
Okay. Does your child's mother work? She may not be working right now. What does she do?
Yes, she works. She still been working with Delta at Delta.
Okay. And how did you meet her?
We've been talking about like 3 or 4 years. I just haven't seen them. Just seen them. Just seen her.
Just met her, thought she was interesting, started talking?
Yes, Sean.
Okay. All right. You have any questions for me?
No, Your Honor. Just want to know.
What's going to happen?
Yes, Your
All
Honor.
right. I'll tell you. So before I do that, Mr. Adams, do you waive any issue from the fact that we are proceeding on a copy of the indictment and accusation?
I do.
Great. Mr. O'Neill, I find there is a factual basis for both your pleas. One of these cases is old. Sounds like you were running around with some guys who may have been a lot of fun, but not necessarily helping you move in the right direction. The other case tells me that you hadn't really gotten out of some of that way of life. In fact, you may have upgraded a little bit. It sounds like it was more marijuana and then some serious stuff. There's not a ton of pills, but those are serious pills. I don't know if you'd expanded your business or what, but I've already told you that's just going to cycle you back in. And next time, I doubt the prosecution is going to say time served. They're going to say he didn't learn his lesson, so we're going to need to stretch it out a little bit more.
Yes, Sean.
Anyway, I find there's a factual basis. I also find that your pleas are knowing and voluntary. Knowing means you've understood everything we've been talking about, or if you didn't, you asked about it and Mr. Abate or your lawyer or I explained it. Is that a fair statement?
Yes, Sean.
Voluntary means no one's forcing you to enter these pleas. You may not be thrilled about going forward, but you're ready to do it because you think it's the right way to move things along. Is that correct?
Yes, Sean.
Then I'm accepting your pleas in the two cases. I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, which you will be for a while, if you have a small violation, we usually call them technical violations, you and probation will sort that out. So if you tested positive for marijuana, they may say you need to go get some drug treatment, but you don't have to come back in front of me.
Yes, Sean.
If it is more serious than that, you disappear on them, you get arrested for anything, that comes back to me, and we work through what the consequences are for your probation.
Won't be in no more trouble, Your Honor.
Okay, don't promise what you can't deliver. Get out there and figure out what's going on. But I hear you. I hope that's what's going to happen. In 19 SC 165326, that's what we'll call the gang case, marijuana, and you were with Mr. Kane and Mr. Pearson and Mr. Williams.
Yes, sir.
I'm going to sentence you on count 1 to 8 years to serve 1 year, and count 2 is 8 years to serve 1 year. Those will run concurrently with each other, and that 1 year I will reduce to time served. It will be a special condition of your probation that you get your GED within the first 9 months of probation. Another special condition is that you not associate with anyone who you think may belong to FBN.
Yes, Sean.
No contact. You're not related to Kane or Pearson or Williams?
No, Your Honor. I haven't even seen him since like 18, 17 when I was going to court.
Okay. Yeah, somehow you disappeared. They resolved their cases and then things caught back up to you.
I was going to court, and then my public defender told me that I think that I was switching judges or something. I was going to court. I kept going to court. Then I just lost the I had moved from 3200 Lakeview Place, and that's how all this just started.
Okay. Well, it's all right. No contact with the co-defendants in this case. That would be Kane, Pearson, and Williams. I'm going to waive your probation supervision fees for the first 3 months, so you can figure out how to start earning a little bit, and you're going to be making sure that your little boy is fed and has diapers.
Yes, Sean.
And then within 2 months after being released, you either need to be a full-time student or working at least part-time. You may not get 40 hours right away. And if you're doing your own thing, that's fine. I'm not saying you have to go work for a company, as long as you can document you're working. If you are not a full-time student or working at least part-time, which means at least 20 hours a week, then you're going to do 20 hours of community service each week.
Yes, sir.
So that's just to encourage you, go to school, work, or do both. Otherwise, that's a lot of community service. In 21 SC 177354, I'm going to sentence you on count 1 to 8 years to serve 1, count 2, 1 year to serve, count 3, 8 years to serve. Oh, let me change all that. Sorry, Ms. Nelson. Count 1 is 3 years to serve 1. Count 2, 3 years to serve 1. Count 3, 3 years to serve 1. Count 4 has to be 5 years, and it has to run consecutive after that. That'll be consecutive to count 1. 1, 2, and 3 are concurrent, so they're all 3 to serve 1. Count 4 is 5 years to serve on top. And then counts 5 through 8 are all misdemeanors. I'm giving you 12 months to serve on those. Those will all run concurrently with count 1. And so what I've just described should be 8 years to serve 1 year, reducing that 1 year to time served, and the balance is on probation. And your sentence in this case will run concurrently at the same time with your sentence in the 19 SC case. So overall, it's a sentence of 8 to do 1. It's a little less probation time than what your lawyer negotiated with the state, but I'm doing that for a reason. If you are gonna mess up, you're gonna do it pretty early on, not 8 years from now. And if you and I are spending time together 9 months from now because you got arrested with another backpack full of dope, I'm gonna have a lot of years to revoke. I only need to revoke 4 or 5 to make life real unhappy for you and maybe get you to make the decision you say you're making now. And I trust you're going to make the right decision,
Yes,
but
Sean.
7 years probation is plenty of time. And there is a bill that looks like it's going to work through the legislature that if you're doing well after 3 years of probation, you may be able to get the whole thing shut down. So that's why it's 8 rather than 10. I hope you are ready to chart a different course. It sounds like 6 months. The county jail has helped you focus on that. Your special conditions in the 21 SC case are get your GED, and then that same situation, you're either working at least part-time, 20 hours a week, or you're a full-time student. Otherwise, you're going to be doing that 20 hours of community service each week. And again, I'm waiving your supervision fees for the first 3 months so you can get on your feet. Mr. Abate, any other conditions or questions or concerns about the plea.
No, just only as to the sentence on count or in the first indictment, the 19 SC indictment. I think you said count 1. He's only charged with counts 2 and 5. So
Correct. You're exactly right. I may have just said 1 and 2, but it's counts 2 and 5.
I just want to make sure.
Yep.
Nothing there.
Yep.
That's it.
And the calendar has it as 2 and 5, so I bet you followed that. Mr. Adams, anything else for Mr. O'Neill?
Just one thing, Jan, I'm not sure what count it was, but it was served consecutively. Would that be suspended?
No, it is probated.
Oh, it is probated? That's fine.
Yeah, because I gave him 3 years on the other counts. I just put the 5 on top of it. 3 plus 5 gets us to the 8.
Okay, good. I'm sorry. I missed that part. Okay.
Okay. Mr.
Judge, I'm sorry. I have one question on the 326 count 5 was the 8 years to serve 1 as well?
Yes, ma'am.
Okay, thank you.
Yep. Mr. O'Neill, in normal times, you would sign the indictment or accusation. Mr. Abate would, and Mr. Adams would. He can't because he's not in the same room. But do you authorize me to sign the indictment for you saying I plead guilty?
Yes, Sean.
Mr. Abate? Yes. And Mr. Adams, may I sign for you?
You sure may.
Great. I think the last thing we need to do is get some information to Ms. Crawford. She's the probation person you see on the screen there, S. Crawford.
Yes, ma'am.
She's going to ask you some questions about your address and get a phone number from you. And she's going to give you some reporting information.
Okay.
The third most important thing after hugging your mom and the mother of your child will be to make this meeting. Because if you don't show up, they issue a warrant. And boy, we're starting off on the wrong foot.
Okay.
So I'll get it written down for you. So you leave with a piece of paper. But let's let Ms. Crawford get your information and we'll go from there.
Good morning. I'm Ms. Crawford from probation. I just need to get an address from you and then I'll give you your reporting instructions. And then I will need your contact person. I think it should be your mom, her telephone number as well. So go ahead with your address.
It's 2330 Delow Drive.
Spell Delow for me.
DELOWE.
Okay. And you said that was in East Point.
Yes, ma'am.
What's the zip code there?
30344.
What is your mother's name
Janice O'Neill.
and her telephone number?
678-709-9762.
Okay, your reporting instructions will be, I'm going to give you the date of March 30th at 9 a.m.
Mm-hmm.
That's 3 weeks from today, Tuesday, March 30th, 9 a.m. You're going to report to 276 Memorial Drive, Southwest Atlanta, Georgia, 30303. And I'm going to give you my telephone number in case you have any questions before I'm reporting.
Yes, ma'am.
It's 470-303-6860. Ms. Crawford.
All right. I wrote all that down for you. I have bad handwriting, but I bet you can read it.
Thank
you, sir.
Do you have any questions, Mr. O'Neill?
No, ma'am.
Let's just make sure you can read my bad handwriting and then let you go.
Marquise O'Neill report to probation on 30 March 20, 9 a.m. Don't miss the 27th Memorial Drive. Yes, sir.
March 30th, right? 30?
Mm-hmm.
That's correct.
Okay. He's got it. Don't lose that piece of paper. Of course, Mr. Adams, you can always reach out to him and he'll let you know about that as well.
Okay.
All right, Mr. Abate, anything else in Mr. O'Neill's cases? Thank you for your help on that. Mr. Adams, anything else?
No, Yana, thank you.
Okay, thank you, everyone. Ms. Nelson, do we have a different Zoom in the afternoon or do I need to keep this up?
You can keep this one up. I'm not sure. I think Ms. Hall has a plea on Mr. Palmer. I didn't know if you could take that any earlier. I'm not sure where Ms. Patel is. So just a thought.
Sure. So I've got this meeting at Assembly Hall at 1. I could do it before 1, we're going to need to start Mr. Franklin's motion a little bit late, probably closer to 2.
Okay.
Because I don't know how quickly I can get out of Assembly Hall. We're meeting with the sheriff's team and Dream about doing jury selection over there.
Okay, let me, are you gonna be in your office, Judge? I'll see if I can get in touch with the parties. See if they
Yep,
can.
I'll just be back at my desk. You can shoot me a little instant message.
Because Mr. Palmer is already over, correct?
Mr. Palmer is here? Yes. Yeah, is he still downstairs?
Okay.
Yeah, so they need to bring him up, but he is here. So if that'll work out, just let us know and we could try to do it before 1. I'm good until 1 o'clock.
Okay, I'll reach out then.
Okay, don't know. We'll let you know. Thanks. Yes, figure out what to do with Mr. Hodge. All right.
I need Carol watching.
See ya. Things going all right in the new regime? Good answer.